Right. If anyone is watching the YouTube stream and could give us just feedback real quick on how the audio sounds, I want to make sure things sound decently balanced.
Yeah, I'm going to talk so that you can get a judgment about that.
Spent a lot of time tweaking this yesterday, so I hope the changes stuck.
You sound a bit louder on Discord than you were last night.
I sound a bit what, sorry?
Oh, the YouTube is way behind. Alright, the YouTube's like 30 seconds behind.
Okay. That's to be expected. It takes a time to...
It does sound balanced, though.
Excellent.
So.
Alright.
I just muted it on my end.
Alright. Well, let's get started.
But I'm not going to be able to see where you are in the opinion, so you're just going to have to kind of keep me posted on where you're scrolling, or else I'll be 30 minutes late. Or 30 seconds late. Yeah, it's an announcement, Neb.
Thank you, Bean.
Yep, cool.
Alright, so we'll start with Raven and I have both gone to law school. Can't say we're lawyers, strictly speaking, because we're not actually on the bar yet. But we're very, very close. So
I'm like a week away.
Yeah. So with that noted, do not take anything we say here as legal advice, which you shouldn't anyway, because none of this is going to be particularized to you, and none of this is based on statutes or anything. This is strictly the Dobbs v. Jackson opinion here. So a real quick preface for non-Americans or people who just don't follow the court. An opinion from the Supreme Court, when you bring a case or controversy to the Supreme Court, they have to decide on the issue in some way. And that decision for the Supreme Court is usually less about the merits of the case and more about what the Constitution or federal law dictates. And then they send the case back down to lower courts to obey their opinion, or, as they often phrase it, conduct further proceedings not in contradiction to this opinion, or consistent with this opinion. And so a whole lot of this opinion in particular is not about the merits of Dobbs v. Jackson. It is about Roe v. Wade. Let's say 95% of this opinion is just explaining how horrible of legal analysis Roe v. Wade was. And
right. So an important backdrop here would be that the reason this opinion focuses mostly on Roe v. Wade and its companion case, Planned Parenthood versus Casey, is because under the precedent set by Roe v. Wade and Planned Parenthood versus Casey, the Supreme Court would have to probably strike down this law, the Mississippi law. So instead of focusing on that law itself, they have to focus on Roe v. Wade and Casey because they have to overrule those cases in order to rule the way that they did on this particular law.
Yeah,
so,
both sides in this case, basically, they were in agreement that this question turns completely on the decision in Roe v. Wade. Both the abortion clinic who was trying to end the Mississippi law and the state of Mississippi themselves. So this law specifically was about banning any abortion before 15 weeks, which was 8 weeks earlier than most states allowed under Roe v. Wade. And so it was seen as an encroachment and infringement upon the right to an abortion that was outlined in Roe v. Wade. And
right. So we should probably explain what Roe and Casey said.
Yeah.
At least in brief. So Roe versus Wade was the landmark decision that started this in 1973. And what Roe versus Wade determined was that there was a right to privacy found in the 14th Amendment of the United States Constitution, which justified a woman having the right to choose to have an abortion. Okay? That's what Roe v. Wade said. And Roe v. Wade set up a trimester framework where the restrictions on abortion would be variable depending on the trimester of the pregnancy that the woman was in. So in the first trimester, there could be almost no restrictions whatsoever. In the second trimester, you could make restrictions on abortion to protect a woman's health. And in the third trimester, you could make pretty broad restrictions if you wanted to at the state level. So that was the law for about 20 years. And then in 1992, that law was challenged in a case called Planned Parenthood versus Casey. And in that case, the court threw out Roe's trimester framework and replaced it with an undue burden standard. So now instead of having this trimester thing, which was not really based in any kind of science or law, they replaced it with a standard that said you can't put an undue burden on a woman seeking an abortion. Okay, and how that's determined would be dependent on Casey itself, as well as some following cases that you sort of ruled on the question of what an undue burden is. Now, the issue in this case is that this 15-week abortion ban, right, would have constituted, under Casey and Roe, it would have constituted an undue burden. Like almost all lawyers would agree that this would be an undue burden. So in order for them to rule in our favor on this case, they would have to overrule both Roe and Casey, or else they could scrap the Casey standard and sort of whittle away. They could keep Roe and Casey and whittle away at it by saying that this isn't an undue burden, but that was always going to be a little bit more dubious of an argument. And as you'll see when we start going through this opinion, they opted to just scrap Roe and Casey entirely.
Yeah, which chipping away had kind of been the modus operandi for dealing with Roe for a while, particularly because of how bad the decision is. Like there have been some very bad decisions from the Supreme Court in the past, and we're not talking bad in just that their results were unethical. It's that their legal analysis was complete nonsense. And so, a great example of this is like Dred Scott or Plessy v. Ferguson. Dred Scott being the right to slavery case, essentially saying that citizenship was not intended for anyone but white people in America. That was completely made up. It just pulled out of thin air by the justices writing that. And Plessy v. Ferguson was separate but equal. Like likewise, where in the heck anywhere in American tradition is that indicated as like what the goal was? And Roe v. Wade is just another example of that. And we'll go through the opinion, so I won't criticize it too much at the outset here, but like that is why this opinion so much focuses on the problems with Roe rather than what's happening in Dobbs and Jackson's case itself.
Right.
So
another thing to think about while we go through this opinion is that the class of cases that Roe v. Wade and Planned Parenthood versus Casey are part of is called the substantive due process cases. Okay, and all of these cases, there's a long history of them, but all of these cases find some kind of right implicit within the 14th Amendment, and the 14th Amendment being one of the post-Civil War amendments. And all of these cases find these rights in this amendment that are not actually written into the text of the Constitution. Okay, so there are a whole host of other cases that that prevent states from banning other things. For instance, states are not permitted to ban contraception under another substantive due process case. States are also not permitted to ban same-sex marriage due to the Obergefell decision, which was also a substantive due process case. So as we're reading through this opinion and listening to the arguments that the justices are making here with this majority opinion, you should probably be thinking about how this might affect those other cases, because this argument, at least from my reading of this opinion, it seems to suggest that they're questioning the legitimacy of all of those cases, not just Roe and Casey. So
it's going to require their analysis for one thing. So
right.
You're going to hear the phrase ordered liberty a lot, and we'll explain that when we get closer to when it starts popping up all the time. But it relies on exploring the history and tradition of Anglo-American common law, and that is really where we begin, because there can't be a right implicit to Anglo-American common law society if there's no history of the right in Anglo-American common law.
Right. And so, we should probably briefly explain what Anglo-American common law is.
Yeah, so common law is judge-made law. Every time you bring a case to a judge, the judge makes a decision, and for a nice mix of consistency and flexibility, judges have a lot of leeway in how they can decide and interpret law, especially Supreme Courts throughout states, or the Supreme Court in the U.S., federal courts generally, because they have to interpret a massive body of law. And if you go to a strictly civil or Napoleonic law society like France, the judge is bound to abide by the letter of the law, and when there's so many laws in conflict, you can end up with some really wacky outcomes. So common law is a better system, despite it sounds like people are making stuff up, but they aren't usually.
Yeah.
Roe is an example where they were.
And common law originated in England. It was a unique product of medieval England. And when the founders of America set up the Constitution, they assumed common law. So, in fact, most of the 13 colonies, still all of them actually, if I'm not mistaken, actually have statutes that receive the common law of England from prior to 1776, and basically say whatever was common law in 1776 is law in our state until it's revisited, perhaps, by the judges of our state in the future. So the common law is not something that is just ethereal and out there and up for debate. It's relatively settled, and it's a matter of historical research, not a matter of interpretation or conjecture.
Yeah. And with that, I think we're ready to start going through the opinion, because we're just going to end up repeating it if we go too much further.
Yeah.
All right, the first thing I would call attention to on page 1 is that second paragraph. As we just mentioned, this all turns really on an analysis of common law and American law tradition. Has there ever been a right to an abortion? Prior to Roe, there is absolutely none. For the first 185 years after the Constitution, each state had their own laws regarding abortion, and as we'll cover, at one point or another, every state outlawed it, almost completely at any point in pregnancy. So the Constitution doesn't say there's a right to an abortion, which basically means you have to find it somewhere implicit to the Constitution. There has to be some other right in the Constitution that implicitly says that abortion is something people are entitled to. And in Roe, the court did not claim that American or common law had ever recognized such a right. And this is one of the things that I really love in here. Right at the top of page 2, Roe's survey of history ranged from the constitutionally irrelevant to the plainly incorrect. And this is just like chef's kiss stuff right here. it's so accurate.
Reading through Roe is tough for anyone that's a lawyer or a historian, because it's so butchered that it like he says.
Yeah, it's discussion. Roe discusses abortion in antiquity, which, like, if you know anything about ancient history, like, there absolutely was not a right to an abortion. It was considered homicide. People who will say that, like, ancient Judaism allowed abortion, like, they're missing a whole lot of restrictions that were built in there. It was definitely not an at-will thing. And at the very least, it was intensely frowned upon.
And it's irrelevant to our Constitution, because the only law that matters is our Constitution and the English common law tradition. We don't care what the ancient Romans did. And it's not relevant to constitutional analysis.
Yeah, and then the assertion that abortion was probably never a crime under the common law. This is just flies in the face of reality. There's no way they actually researched and came to that conclusion.
And we'll see that they didn't.
It's just total nonsense. Let's see. Moving down. Right, so the opinion in Roe, end of the first paragraph on page 2 here. The opinion concluded with a numbered set of rules, much like those that might be found in a statute enacted by a legislature. When we say that common law is judge-made law, the judge creates interpretations and applications of law. The judge cannot make a statute, or at least they're not supposed to. That is a gross misuse of their power. But that is exactly what Roe did. That trimester framework, first off, it's completely arbitrary. If you actually know anything about pregnancy development, you can say that, yeah, there's generally things that happen in the first trimester that are different from the second trimester. But what is different in week 12 that makes it completely separate from week 14? That week 13 dividing line of the trimester is completely arbitrary. There's nothing specific on either side of that within the human body that is like, yes, we are in the second stage of this pregnancy. In fact, the word trimester was invented in the 19th century. And it wasn't invented in this regard. It was just a period of 3 months.
Right, it had nothing to do with the common law.
Yeah. And so they invent this framework of, at one trimester the state can do X, at the second trimester the state can do Y, and neither party in Roe actually proposed this. Nobody proposed this. It was never even a question in legislation. And so at this point they are the Roe court is straight up just inventing law here and deciding that this is the law of the land, which they're not supposed to be doing. And Alito writes later in this paragraph here, the court did not explain the basis for this line. Even abortion supporters have found it hard to defend Roe's reasoning, which is true, especially back in the 70s and 80s, when there was a bit more intellectual integrity on this point. Everyone in the legal field knew that Roe was rocky. That's why there's always been a question of it getting overturned. If it was as clear as abortion advocates would like to claim, there would be no chance of it getting overturned. All right, Alito points out here at the end of page 2, at the time of Roe, 30 states still prohibited abortion at all stages. All right, so this is, at this point, just to highlight how much Roe is changing the status quo. they aren't basing things out of law in the current system in America. They are making a new framework that directly overrides the majority of the union. Do you have anything to add on page 2, Raven?
No, I think you covered it all there.
All right. So down page 3.
So then we get to Casey.
Yep, we finally start talking about Casey.
So Casey tried to deal with this issue that Roe was obviously shaky, and so the hope for people on the pro-life side was that Casey would actually lead to an overturning of Roe, but instead we had a three-way split, because Roe itself was extremely rocky and nobody really knew how to deal with it. So we had 2 justices who said they wanted to keep Roe. 4 others wanted to overrule the decision, which would have been what is happening today. And the 3 remaining justices signed a controlling opinion that did not endorse Roe's reasoning, but created this new standard. So there's another legal doctrine which we haven't really mentioned yet, as far as I'm aware, called Starry Decisis. And the principle of this doctrine is sort of central to the common law system. So the idea is that once a case has been decided on the merits, the decision should remain untouched, right? We're not going to have decisions that are overruled consistently, because then people don't know what to expect from the law, and if people don't know what to expect, then the law is kind of useless. So this principle is very important in constitutional law and in common law, judge-made law generally, and but it has some exceptions. And so we're going to see later in this opinion what Justice Alito and those who signed on with him think those exceptions are. But suffice to say that the court in Casey was uncomfortable with overruling Roe because they considered it a matter of settled law under the principles of stare decisis. However, as Alito points out here on page 3, they're overruling Roe in all but name, right? They're keeping Roe's essential holding that abortion is a constitutional right, but they completely scrapped the trimester framework and replaced it. He says here, paradoxically, the judgment in Casey did a fair amount of overruling. They completely scrapped the trimester framework and substituted it with this rule of uncertain origin that states are forbidden to adopt any undue burden on a woman's right to have abortion. So you can see how they have completely fabricated this, right? The undue burden standard, first of all, has no basis at all in any law prior to 1992. When Casey was decided. So it's not like this was a common law standard or something that the states had prior to the adoption of the 14th Amendment. But it also shows that they really weren't all that serious about stare decisis because they were completely content to overrule Roe.
Yeah, Casey is a gymnastics move very much intended to try to preserve abortion, despite the fact that justices really did not want to endorse Roe's reasoning, because they couldn't really. So, noting stare decisis and the concept of settled law, truly there's not really any such thing as settled law, except maybe a constitutional amendment that is ridiculously clear. All judge-made decisions can be overturned. All legislation could be, struck down or repealed or overridden or amended. So the concept of settled law is a bit of a misnomer. What it generally means is that there's been a decision on the matter. It's a very persuasive decision, or at the least controlling. But as we say with Roe, there was an opinion, and it was controlling for a while, but it's not well reasoned. So stare decisis, it's having a really hard time with this already by the 90s. And in 1992, we're not even 20 years post-Roe yet.
Yeah, it was 19 years after Roe.
Yeah, and this viability standard they have here, an undue burden, like, viability is increasingly arbitrary. One of the things that, I guess, is where we can start doing some Christian analysis part of this. Viability is a completely arbitrary standard, at least from a Christian perspective, because who determines when an unborn infant is viable? Say you have a unborn baby who is, born prematurely, a couple weeks early. 100 years ago, that was a huge hit on their mortality rate. But now at this point, like, there's preemie clubs. Like, it's basically a meme to be a preemie at this point. I think it's scary as a parent, but your kid is very likely to survive only a few weeks early. What about as early as, like, I don't know, 23 weeks? I think there's been children that have survived being born as early as, like, 25 weeks. That we only can do that with modern technology, but is that viable? Why is the same child viable in 2022 that was unviable in 1922? How can we say, as a matter of life and philosophy, that, like, this is an okay standard? It is completely arbitrary. Now, what about a child who is born with cancer? Is the child viable? What mortality rate are we considering viable here? And does the Constitution
and
really
how is that relevant?
Yeah, and does the Constitution really grant this authority of life and death over human beings to, bureaucrats who come up with these arbitrary standards?
And would anybody prior to 1973, but especially prior to 1865, would anybody have considered viability even a cognizable term? Right? I mean, it would have had they probably would not have even had much of a conception of fetal viability prior to the introduction of modern medical technology, because infant mortality rates were extremely high even for full-term babies at that time compared to today. So it's really entirely arbitrary, and it has no basis in law or in science, right? I mean, is something less human because it's not yet a viable life outside of the mother's womb?
Yeah. So on page 4, Alito starts addressing the undue burden thing, which is a likewise arbitrary standard, though right now it's only briefly explained that how do you tell the difference between a due and undue burden? Usually, if the state is going to intrude on any civil liberty, it must have a rational basis for doing so, and do so in the least invasive means possible. But if you were to say that there is a total right to abortion on demand, any burden would be an undue burden. But our decisions we're relying on, Casey specifically, doesn't really explain that. It doesn't say that there's a total right to abortion on demand. It doesn't explain where that line between due and undue is going to be. But that is what it has done. As of 1992, Roe's trimester framework is thrown out, and it's just this undue burden standard that nobody can explain. And then the court, this shows you how out of line even Casey was. The court called the contending sides of a national controversy to end their national division. Who made the Supreme Court, like, the moderator in public discourse?
Yeah. Well, part of the reason Casey is so strange is because it wasn't actually a full majority opinion. So everybody had to put their fingers into it to get something that they wanted put into the case in order to even get a decision on the case in the first place, because of the fact that it was a three-way split. They didn't actually have a single controlling majority. So I think we're ready to talk about page 5, where we might be ready to talk about the Glexberg case and why this is relevant, and how the due process clause is being treated. So remember what I said earlier, that the due process clause is part of the 14th Amendment of the Constitution, and it says that you cannot remove a citizen's rights without the due process of law. Okay, so at the time, this is after the Civil War that this amendment was enacted. At the time, that was understood to mean the due process of law. Okay, meaning you have a court, you have a trial, you have a jury, then you can put somebody in prison. You can't just lock somebody up without a trial. You have to go through process. This is a very English tradition, where we set up all these processes with the expectation that as long as we follow the process, we're going to be ensuring a more fair outcome. So what these due process cases had determined was that you could use that clause to invent rights that did not exist at common law and say that they're in the Constitution through this clause. Okay, so the Glexberg case in 1997, Washington V Glexberg, was about euthanasia. Somebody wanted to have a physician assist them in killing themselves, and that was illegal under the law of the state of Washington at the time. And it went up to the Supreme Court, and the Supreme Court heard arguments to the effect of, well, actually, this euthanasia should be a 14th Amendment due process right. Okay, so they wanted to treat euthanasia basically the same way that they treated abortion, and they wanted to find it in the Constitution. However, in a almost unanimous opinion, I think it was unanimous actually, the Supreme Court held that there is no due process right to euthanasia because it's not, quote, implicit in the concept of ordered liberty or, quote, deeply rooted in this nation's history and tradition. Okay? So what that means is that this Glexberg case in 1997 sort of had language in it, and keep in mind this is a unanimous case. Justice Ginsburg was on this case. Several other liberals signed on to this case, and what they said is that if a particular proposed right is not something that's deeply rooted in the nation's history and tradition, it's not part of the 14th Amendment. It doesn't get piggybacked into the Constitution based on the 14th Amendment. So
you should explain the piggybacking
case
a little bit real quick.
I'm sorry?
We should probably explain the piggybacking a little bit, the incorporation.
Right.
So the Constitution sets out rules for the federal government, and in the 10th Amendment it explicitly kind of gives back to the states anything else not mentioned. Well, one of the things that the 14th Amendment did was incorporate the rest of the Constitution onto the states, but not completely. So there's three levels of this incorporation. There's total incorporation, which has actually explicitly been rejected by all wings of the court throughout history. I don't really understand the full reasoning of that. Like, if it's good enough for the federal Constitution and we're going to incorporate anything on the states, then the whole Constitution should be incorporated. But that's beside the point. That has been rejected. The other would be I'm forgetting the term, but basically a picking and choosing of which amendments to incorporate. And this was popular for a while and basically resulted in the first 8 amendments being incorporated onto the states to some extent. And then there's the one that we're going to hit throughout here a lot is ordered liberty. And that's the principle that this right is inherent to a ordered and liberded society. And one of the things I really like about how much they use this is, like, Justice Breyer loves ordered liberty. Like, he's been all about it throughout his whole career. Ginsburg was a big advocate of it, and so in organizing the opinion this way, Alito has turned many arguments of the pro-14th Amendment, pro-incorporation, seemingly liberal jurisprudence against itself for the purpose of overruling Roe v. Wade.
Right.
All right, please continue with Glexberg from there.
Yeah, so this ordered liberty, the language of ordered liberty actually comes from Glexberg, which I don't recall who wrote Glexberg. Apparently it was Chief Justice Rehnquist. Yeah, it was Chief Justice Rehnquist, who was a conservative. But the basic idea is that the piggybacking, right? I call it piggybacking because that's sort of what it means. The piggybacking is something that would happen if you had a right that was implicit, and this one is not, right? The euthanasia is not. And so throughout the rest of this opinion, what we're going to see is that Alito is going to compare abortion to the euthanasia in Glexberg, and likewise, we're not going to find abortion when we get into the historical part of this opinion. We're not going to find that in the common law. We're not going to find that in the pre-existing rights that were deeply rooted in the tradition of the country, right? And so maybe somebody might ask, okay, well, what is an example of a right deeply rooted in the tradition of the country? Well, one example of something that's not codified in the Bill of Rights would be the right for parents to make decisions about their children. It's not codified anywhere. It's not written anywhere in the Supreme Court. The Supreme Court doesn't even have really many cases about this. It's not written in the Constitution. It's not found explicitly in statute anywhere in the common law. But this is a right that people have had forever, right? It's something that we would consider to be deeply rooted in the tradition. So if there were ever a challenge to a parent's right to make decisions about their child, then it would be analyzed with the assumption that there's a right there. It might be a limited right, but that there's some kind of right there that is piggybacked in to the Constitution through the 14th Amendment under this concept of ordered liberty. That would not be possible if we took a strict reading of the 14th Amendment, but it is with this ordered liberty conception. So that's an important distinction to make. It's not as simple as if it's not written in the Constitution, it's not there. It's not quite that simple.
Well, and part of the reason for that would be there were some things that are so intrinsic to Western civilization that the founders never would have thought they needed to write down. Which tells you how far we're getting away from, antiquity and our founding, that we have to ask these questions that, like, if you had asked any of the founders what they thought about abortion, this never would have been a question.
And that would be the same for a lot of the other 14th Amendment cases that have been decided recently.
Yeah.
So
what Raven has just explained there is right at the top of what's the second started paragraph, the third paragraph on page 5. The right to an abortion does not fall within this category. That category is what he just explained. And it's specifically because at the end of that paragraph, Alito points out, even Roe and Casey acknowledged that it was different because it destroys what even those decisions were calling, quote, fetal life, and what the law in question, this is the little bit of merits on Dobbs that we start talking about, in the law in question, the state of Mississippi has determined through its legislative process that this is an unborn human being.
Right.
And then on page 6, we really get to the beautiful parts of this decision, or at least the draft decision, Roe was egregiously wrong from the start. This is a sentence that I think these justices have been waiting to write for their entire careers.
Yeah. And you know what? The honest truth is that if you ask a liberal lawyer, they would agree with that in private. Because nobody picks up Roe and reads it. Like, we all have to read it for constitutional law. Nobody picks it up and reads it and think, oh, wow, this is a brilliant case. Right? The people who like the outcome sort of excuse it because, well, I like the outcome. But nobody reads it and thinks it's a good law. So,
yeah, we're going to read at one point in here, even Justice Ginsburg did not approve of the way Roe was decided.
Right. So, this paragraph at the top of page 6, he says, "It is time to heed the Constitution and return the issue of abortion to the people's elected representatives." So what this means, this is an important thing to clarify for everybody here. All right, the fact that we're saying that abortion is no longer a constitutional right under the 14th Amendment does not make it illegal. It leaves it up to the individual states to determine, consistent with their legislative process, what they want the restrictions on abortion to be. So for some states, that might end up being no restrictions, and for others, it's going to be, they're going to have pro-life laws.
Yeah, near total bans.
Right.
Are very likely. And so here's an example of one of the bans, the actual law in question in Dobbs. We're gonna address that statute a bit here. Starting section 1 on page 6, we've mentioned that they don't use the term fetus. They have rejected the pro-abortion side's language and explicitly call this an unborn human being. And it makes notes. It makes note that only 6 countries besides the U.S. and like if you look at a map of the world and their abortion laws, like especially as Christians and pro-life people, you're going to be shocked at just how accessible abortion is. But only 6 countries plus the U.S. allow abortion on demand after week 20. That's how barbaric the U.S. standard has been for all this time. That even the majority of Europe doesn't even allow that. And from there throughout page 7, Alito is explaining the Mississippi legislature's legislative process, how they came to these conclusions. And this isn't to analyze Mississippi's conclusions, it is to explain what the process is and how it's reasoned. If a court was to make a decision like they did with Roe, they're basically pulling a decision out of nowhere and being completely arbitrary about it. And they are ruling by fiat from the bench how their jurisdiction is to be governed. But in a legislative process...
It's often called judicial activism.
Yeah. In a legislative process, people have to convince each other, and they have to come to conclusions, and there's committees, and they do research, and they incorporate things in their laws very often that state what their purpose is. And this is because some people are intentionalist, and that they believe laws should be judged based on what they were intended to achieve, which is iffy, but we'll sidestep that. And Mississippi, in this statute, has explained their reasoning. At this point, the heart is formed. They're moving in the womb. All physiological functions are there. Vital organs are running. Hair, fingernails, their diaphragm. They're going to start moving about. By 12 weeks, they have taken on, quote, the human form in all relevant respects. All right? And then to have an abortion past that point requires dilation and evacuation procedures which involve the use of surgical instruments to crush and tear the unborn child. This is directly from the statute in question. intentional commitments of such acts is a barbaric practice. And I would agree with that. And the statute makes really effective use of this violent imagery, because this is the aspect of abortion that abortion advocates will never see, or at least they refuse to see, is that this isn't, some clinical procedure that is completely clean and not messy. Like, you're ripping apart something that looks human in all relevant respects by 12 weeks. And the reason the 12 weeks is important, and why the 15 weeks is like such a touchy thing for abortion advocates, I mean, other than the fact they're really into abortion, is that a lot of women can't actually tell they're pregnant. Like, the almost minimum to tell you're pregnant is like 8 weeks. There are tests that can determine before that, but like if you're not testing and you don't suspect that you're pregnant, you could very well go past 15 weeks without knowing. And so that is their rationale for why this is an undue burden.
Right, it's almost certainly an undue burden under Casey. If you're going to read Casey and apply it, it's this law should be struck down.
Yeah.
So, do you have something?
I was just gonna say that was all I had on page 7, and yeah, page 8 is just an outline. So I was gonna just go over that real quick.
Yeah. Okay,
so on page 8, we've got our outline for the rest of the opinion here. First, we're gonna look at the standard that 14th Amendment cases have been decided on in the past. Second, examining the right at issue, which is abortion, and whether or not it is rooted in the nation's history and tradition, whether it's part of ordered liberty, and last, whether a right to obtain an abortion is supported by any other precedent, which we already know their conclusion is going to be no.
Right.
All right, so Now we're really getting into meat and legal analysis and reasoning of ordered liberty. So, under A1, page 9, those who claim that the Constitution protects such a right must show that the right is somehow implicit in the constitutional text. As we've explained, if it's not outlined specifically, it must be implied somewhere. And in Roe, they held that the abortion right, it's not mentioned in the Constitution, but it's part of a right to privacy, which also is not mentioned in the Constitution. The right to privacy is pulled out of an implication from like 5 different constitutional provisions: the First, Fourth, Fifth, Ninth, and 14th Amendments. And then from that, you can somehow derive that there's a right to an abortion. It is a tremendous leap, which I guess we should add that this probably doesn't flag as much to people who like don't read a lot of court opinions, but for the court to base a decision on 5 different constitutional provisions is insane. Like that really shows that they're throwing law at the wall to see what sticks.
It's a grasping at straws kind of approach.
Like you never do that, because like when you're analyzing very basic things of like, does Congress have the power to do this? You don't even look at whole provisions. You look at singular clauses. Is this in the Commerce Clause? Is this in the Establishment Clause? Does these clauses allow this? And to come to the conclusion that the Due Process Clause in the 14th Amendment supports this, you need to rely on at least 4 other amendments to help you make that logical leap. It's right. Really quite incredible that they did that. And so,
although the principal one that they rely on is the 14th Amendment.
Yeah. And
which
so
is not.
We've got 3 ways in which they've come up with that combination of provisions and how this justifies this. So, that the right is founded in the 9th Amendment's reservation of rights to the people, which is dubious, and if that's so, then why wasn't that right reserved to the states under the 10th Amendment as well?
Right.
Another was that it's rooted in the First, Fourth, and Fifth Amendment, and some combination results in this incorporation. And so, the first being, religious liberty, I presume, your right to decide
I think
whether,
that's where they're drawing it.
Yeah, whether or not you even believe this is a person. I guess that's a matter of religious.
This is where
thought.
the mystery of life passage. I think that's in Obergefell. But in one of these 14th Amendment due process cases authored by Justice Kennedy, there's a passage where they talk about how the 14th Amendment with the First Amendment confers on people a right to determine their own answers to the questions of the mysteries of life, which is a fancy way of saying we think you should have a right to kill your kid because freedom of religion implies that the Constitution considers this an entirely personal matter. It's as ridiculous as I'm making it sound. But that's I think why they draw in the First Amendment.
Yeah, and then the fourth is against government invasion, which, oh man, to get into Fourth Amendment analysis here, like there's no requirement that police get a warrant for the state to say an abortion clinic should not operate. Like that, you don't have to intrude on the woman to ban abortion. Yeah. Right. And then Fifth Amendment of self-incrimination, like. Okay, again, we don't even have to target. We don't have to target the woman, and there's more ways to convict on this matter than self-incrimination.
Well, I think the argument is that because the Fifth Amendment protects against self-incrimination, that implies that the founders care about somebody's right to keep the incriminating information private, and that therefore, when combined with the other three, it creates a right to privacy. Right.
Yeah.
Remember, they're making two logical leaps here. They're first inventing a right to privacy, and then they're inventing a right to abortion that falls under that invented right to privacy. So, it's really ridiculous.
And so the ridiculousness of these first two and how incoherent they are is why there is a third, and the third is what most abortion activists have relied on, is that these other amendments played no role. It's all the 14th. It's all liberty protected by the Due Process Clause. And that's where we have to come to the point of ordered liberty again. Is this liberty essential to the civilization that America considers, right and proper? And I love this provision, or this note. Starting on page 10 here, Roe expressed the feeling, in quotes there, that the 14th Amendment was the provision that did the work, but its message seemed to be that the abortion right could be found somewhere in the Constitution, and its exact location is not of importance. That is legally nonsense.
It's so lazy.
I can't imagine doing that for any law. Like, you're examining the constitutionality of a congressional act. It's in there somewhere. Don't worry about it.
Yeah. This would be ridiculous on any other question, but because it's abortion, people defend it. It's pretty much that simple.
Yeah, and Casey did not defend any of this. They didn't go into any of this. Yeah, so Alito will address that theory, but there are 156 different briefs that were submitted to the court by things called amicus curiae, friends of the court. They're not parties to the case; they're just people who like to file briefs, and the point is supposed to be like to help advocate for things when there isn't a party or if it's a major question. But really, what it amounts to is different non-government organizations just wanting to, signal their virtue and be like, we did something on this issue. So there were a ton of amici briefs, and some of them have tried to suggest that it's under the Equal Protection Clause, which is to suggest that to outlaw abortion is to discriminate against women. And, of course, you have heard this in public discourse all the time. Like, reproductive rights, women's rights, they want to control women.
Birthing people.
Yeah, not even women at this point. So Alito addresses this and basically says the sex discrimination concept is garbage. Neither Roe nor Casey ever invoked that theory, and it's squarely foreclosed by precedents within the court, because abortion is not a sex-based classification and is not subject to the heightened scrutiny to which that kind of standard would apply. The fact that only women can have abortions, or I guess now birthing people, which, man, does that concept undermine the idea that this is sex discrimination? The fact only women can have it does not make this an unjust thing to govern that is inherently discriminatory. Only if the law was passed as pretext designed to discriminate against women, then you could say it violates the Equal Protection Clause. But otherwise, this is neutral, and the fact it's only women is just coincidental.
Right. It would be like making a law banning anime and then having men claim that it was sex discrimination. Yeah. No, that's a cheeky reference, but like pick something else that mostly affects one gender and ban it, right? It's not going to be considered sex discrimination because the law on its face doesn't say that a woman can't have an abortion, right? Theoretically, under laws that ban abortion, nobody can have an abortion, and they're typically directed at the abortion provider anyways, which is oftentimes a man. So it's not an equal protection issue at all.
And so on page 11, we get our first hint of what the standard for analyzing these cases is going to be. Laws regulating or prohibiting abortion are not subject to heightened scrutiny, which is a standard of just really analyzing, like, is this pretextual? There's a presumption that something fishy is going on. They're under heightened scrutiny. They are governed by the same standard of review as other health and safety measures, which means it's a standard law, and it's on a rational basis, which means the state just needs to have a rational basis for wanting to govern this stuff, and they're presumed to have one. And that'll be addressed in more detail later.
Laws almost never get overturned on rational basis review.
Yeah.
So.
All right, so Section 2 on page 11, our decisions have held that the Due Process Clause protects two categories of substantive rights. And the first is the first 8 amendments, which we mentioned. They were incorporated fairly early. Excuse me.
Called the Bill of Rights.
Yeah. Basically the Bill of Rights, except for the part that applies to the states. Excuse me. And abortion clearly is not in that category, so we can skip over that. The second is the select list of fundamental rights that are not mentioned anywhere in the Constitution. The court asks whether the right is, quote, deeply rooted in our history and tradition, and whether it is essential to our nation's scheme of ordered liberty. And I really like ordered here because it implies that this minarchist, libertarian, hands-off government, that's not what's being advocated by the term liberty here. We're talking about an ordered and structured society that tries to allow its people to live as freely as it can within that order. Right.
It's actually a very Catholic conception of what liberty should be, which I always find interesting. And it's worth noting that the quote that Justinian just read is actually the writing of Justice Ruth Bader Ginsburg. She's the one who penned that in the Timms case. It comes from the Timms case, which you can see on page 12. that it has to be fundamental to our scheme of ordered liberty and deeply rooted in the nation's history and tradition. So this is not just conservative talking points, right? This is something that is very deeply rooted in the tradition, on both sides.
Yeah, and we'll skip over most of page 12 and the first half of 13 here, because this is really just historical judicial precedent that all says the same thing about how we come to the conclusions of ordered liberty. And what that passage is really for is just to say to future courts and future law students, like, this isn't something we've made up. There's a long record of this, and in fact, your heroes have advocated for the same thing. So on page 13, we get to historical inquiries are essential when we are asked to recognize liberty protected by due process, because the term liberty alone provides little guidance. A quote from Lincoln: "We all declare for liberty, but in using the same word, we do not all mean the same thing." And anybody reading that in the context of the Civil War knows exactly what Lincoln is talking about there. And I think that is an extremely apt comparison in terms of abortion. How are you to say, those poor people in bondage aren't entitled to liberty? It's my liberty to oppress them. How can you say the same thing to unborn human beings?
Right, and likewise, in Glexberg, where they held that assisted suicide is not part of the Anglo-American common law tradition, that's also not something that, right, from a Christian perspective, you don't have a liberty to assisted suicide. Right, we don't have liberty to do things. There are certain things that no amount of consent can justify, because it's just inherently wrong to do them. And so even, this libertarian idea that, hands off government, let me make my own decisions, let people do what they want, right? There are certain things that people just don't have a liberty to do, even if it's only affecting, purportedly only affecting them. And that includes things like assisted suicide and abortion.
Yeah, cries of liberty does not a right make.
Right. So I don't think we need to go through the historical details in, page by page.
Yeah, we can run through quite a lot of the next 2 pages here and jump straight to 15.
It's worth mentioning that there was another line of substantive due process cases from the early 20th century that the Supreme Court ultimately rejected and scrapped. This being, I believe it was related to unions, right? The Lochner case. He talks about it later here, right?
Yeah, in one case, we used 3 examples of just terrible cases that the court has had to throw out. Lochner is one of those that Lochner was the overruling, I think. I forget which way it goes, if Lochner was the second one or the first one, but the point is there was a law basically saying minimum wage cannot be allowed. It's an infringement on employer rights and
freedom of contract.
Yeah, freedom of contract, and in the context, it was essentially on minimum wage for women specifically, which is just extra irony. So of course the court had to overturn that at some point, because that's just nonsense. Yeah, and so on page 15 we get to the real run up to the Roe decision, and this is just such a powerful statement that I love that somebody's actually saying out loud, because people have been scared to for forever. Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. Zero, none. No state constitutional provision had recognized such a right, and until a few years before Roe was handed down, no federal or state court had recognized such a right, nor had any scholarly treatise of which we are aware. And although law review articles are not reticent about advocating new rights. The earliest article proposing a constitutional right to abortion that has come to our attention was published only a few years before Roe in 1968. I quoted that whole paragraph verbatim except for pointing out 1968. Because like this is something that like people would just be scared to say and point out in law school, yet everybody knows is true.
Yeah.
And that this directly ties to the sexual revolution of the 60s and 1968, and just how much 1968 really screwed up our perceptions of, freedom and gender and relationships. Because
Right. Well, it may be worth actually getting into that because while it's not, he doesn't talk about it in the next few pages here. It is relevant, and he mentions it later. The Eisenstadt and what's the other one? Griswold versus Connecticut cases, which are predecessors of Roe, that also used this 14th Amendment claim in the late 60s to put a federal ban on restrictions for contraceptives. So these are like the very run up to Roe versus Wade. There was this challenge. Lots of states had laws banning contraception, right? Usually with certain exceptions. And there was a person who sued in, I forget which one was first. I think it was Griswold.
Yeah, Griswold first.
Griswold versus Connecticut. And they sued and they said, we're a married couple and we want to use contraceptives and we believe we have a constitutional right to privacy that the government can't tell us we can't use contraceptives. And the Supreme Court in that case found a 14th Amendment right to privacy to use contraceptives. Okay, they said that this is a fundamental right that you have, that the government can't get into your bedroom, right? So you can already hear, this is in the 60s, remember, but you can already hear the kinds of arguments, right? Since we're talking about this decision from a Christian perspective, you can hear the cultural rot starting with that case, the Griswold case, which I think is appropriately named because it sounds grisly. So that said, for married couples, the decision they ultimately reached was that the Supreme Court, the Constitution, demands that married couples have a right to use contraception. All right, so fast forward like 3 years, they decide Eisenstadt, which expands that right to anybody. So they were kind of coy about it in the first one, saying, oh, well, married couples have the marital bed is a private space and the government shouldn't impose on it. Right, but then 3 years later, they just say, oh, actually, it doesn't matter if you're married or not. Anybody can use contraception. And so that's why no state in the Union is permitted to have a law banning contraception in any way, because it's considered a fundamental right. And so, obviously, from our perspective as Christians, we see this not contributing not only from a legal perspective, but from a cultural perspective to the mindset that led to Roe versus Wade. And it also makes possible the sexual revolution and all of the attendant ills that come with that. So it's kind of a twist of historical irony that both of these twin social evils, right, abortion and contraception, are actually based on the same bad constitutional law. So.
Yeah,
and both Griswold and Eisenstadt were cited extensively in Roe because it was basically the same court who decided all three of them.
Yeah, we're sliding at this point in the development of this. We're sliding straight into modernism. That, sex and free love, man. Like, no responsibility should be tied to anything.
Right.
Yeah. And so concluding at the top of page 16, Roe either ignored or misstated the history, and Casey did not reconsider it. So these decisions are based on completely incorrect historical facts, both legal and traditional.
And the next couple pages of this opinion basically detail the history of abortion restrictions, which at common law were it was broadly prohibited after a period called quickening.
Yeah.
So quickening was a legal term in pre-modern England that basically was whenever the woman first feels the baby move. And the pre-modern common law considered any killing of an infant after quickening to be murder, right? It was equivalent with homicide. And Blackstone's, all the like premier legal writers that are looked to for their treatises on law, they have writings detailing that this is a heinous moral crime, that it should be treated the same as murder, etc., etc.
I mean, it's a felony. You got women being put in the pillory for days and then in prison for years, and that's
right.
Both, not either or.
Right.
Yeah. The basis for the quickening is just that without modern medical stuff, that was really the only time you could tell that the pregnancy like wasn't miscarrying and was like there. Because if you don't have a pregnancy test, especially a highly accurate one like we do now, how do you tell you're pregnant? And a lot of men, especially young men, will ignorantly say something like, "Well, what about your missed period?" Well, periods aren't completely regular in a lot of women, especially each month. So that's not a reliable determination either. And so quickening was likewise arbitrary, but it was just based on that's what we could tell at the time.
And it makes sense too, because murder at the time, especially the further back you go, murder was almost always a capital crime. So we wouldn't want to execute somebody without actual knowledge that there is an actual human life in existence in the mother's womb at the time that the person committed the act, right? So it makes sense that they had this quickening standard under common law. But I think it's fair to assume that the common law didn't look positively on people aborting a child before quickening. They just didn't have any knowledge about whether there was a child there or not before quickening. So, and they cover this in this.
Yeah, while we're breezing through the historical background here, I just want to point out on page 19 at the very bottom here, we're talking about historical records of early American law, and there's a point here that Blackstone's Commentaries is one of the most important ones. And I point this out because they cite District Columbia v. Heller, which is like a big Second Amendment case, for literally no reason other than just to say that. And I thought that was just funny.
You don't even really need to cite that Blackstone's Commentaries is an important early edition. He's almost literally just like dabbing on these people by like
that's a judicial
bringing up Heller. When DC versus Heller was decided, it was like there was a huge reeing about it. Let's just say people were not happy. It's a big Second Amendment case. So yeah, it's he's just having a little fun, I think, with that part. Yeah. Or one of his clerks is, you know.
So down on page 21, we get to the distinction between pre and post quickening, which we've just explained the real basis for. But the Solicitor General, who's advocating on behalf of the U.S., which wasn't a party to this case, but they wanted to get a brief in, and the Solicitor General usually has a right to on any case if they want to. They propose that the quickening concept was because before that it was not regarded as having a, quote, separate and independent existence. They have one case to rely on this, and it's disconnected from all other contemporary conversations on the matter. So this is an example of, you writing some nonsense in a paper and then going to find any source you can to cite it. This is not a reliable proposition either. And then the quickening rule itself was abandoned in the middle of the 1800s because it was, quote, neither in accordance with the result of medical experience nor with the principles of common law. So at this point, we're still by mid-19th century, abortion is illegal in every state throughout basically all of pregnancy. And even by now, we're like, quickening is arbitrary. So that's not going to be the standard we have either. Let's see, page 23 is more history, so we'll speed through it, but I just want to read a couple of the points here. By 1868, when the 14th Amendment was ratified, 3/4 of the Union, 28 states, had enacted statutes making abortion a crime even if it was performed before quickening. Of the 9 states that had not yet criminalized abortion, all but one would do so by 1910. The following 13 territories that would become states, all would do the same thing. The Kingdom of Hawaii, which wasn't even close to a state at that point, still 100 years pre-state, criminalized abortion at all stages of pregnancy by 1850, and New Mexico did so in 1919. By the end of the 50s, according to Roe's own court, all but 4 states in the DC prohibited abortion, however and whenever performed, unless done to save or preserve the life of the mother. But yet Roe somehow discerned, quote, a trend towards liberalization in, quote, about 1/3 of the states.
As if that's relevant at all.
It's not only incorrect, it's also just it's blatant judicial activism. They're acknowledging that, like, that this isn't the law anywhere, but it looks like it might be in the future, so we're just going to speed that along. It's
right.
Yeah, it's utter nonsense.
This page 24, the bottom, section 4 here, this is really the capstone of the historical discussion. He says, the inescapable conclusion is that a right to abortion is not deeply rooted in the nation's history and traditions. On the contrary, an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973. The court in Roe could have said of abortion exactly what Glexberg said of assisted suicide. Attitudes toward abortion have changed since Bracton, but our laws have consistently condemned and continue to prohibit the practice. So, this is really the key here, is that it's not there. There is no historical right to it. It's just like assisted suicide. It's a novel modern concept that has been retroactively piggybacked onto amendments that were written by people who could never have imagined that they would be used in such a horrible way.
So the respondents, the abortion clinic, and their amici have no persuasive answer to that lack of historical evidence. Neither the abortion clinic or the Solicitor General disputes the fact of abortion being criminalized all this time. The respondents argue that it does not matter that some states prohibited abortion at the time, but that contradicts the principle of this ordered liberty thing. If ordered liberty requires this right or implies this right, then the right would have existed at the time that the amendment you're relying on incorporated it upon the states. And it absolutely did not do so.
Right.
Respondents and amici were unable to show a single authority, not one, for the existence of an abortion right that predates 1968.
Which is 100 years after the 14th Amendment was ratified. Just for reference.
Yeah. And so...
a few respondents and amici muster historical arguments, but they are very weak. The Solicitor General repeats Roe's claim that it is doubtful abortion was ever firmly established as a common law crime, even with respect to the destruction of a quick fetus. But as we have seen, great common law authorities like Bracton, Coke, Hale, and Blackstone all wrote that a post-quickening abortion was a crime, and a serious one at that. So they basically just are making things up, honestly.
Yeah, one of the things that gets made up here, and I'm loving that Alito addresses this, is that Roe was very largely based on two I don't know if they were law review articles, but some type of scholarly article by pro-abortion advocates in the 60s, the ones from 1968, claiming that basically these historical authorities, specifically Koch, were just nonsense and they were making stuff up. And these articles have since that case been completely discredited. Nobody can seriously defend them. And yet those academic articles are what Roe v. Wade was decided upon. That was the persuasion.
Basically, just to underscore how ridiculous the claim of the articles was. The claim is that because the legal Coke specifically, but I think the argument is more general. Because these legal scholars personally opposed abortion, they deliberately lied in their treatises written hundreds of years ago about what the state of the common law was regarding that question. Right. So it's almost to the level of a conspiracy theory that it's that kind of historical ignorance, honestly, and that's why the article is credited.
There is another conspiracy theory that we're going to address here that one of the amici seriously proposed. Real quick before that. This is a legal distinction. The fact that many states in the late 18th and early 19th century did not criminalize pre-quickening abortions does not mean that anyone thought the states lacked the authority to do so. The best case that they could possibly argue, as far as this being based in tradition as well, pre-quickening, there were plenty of states that didn't outlaw it. Even if that is true, that doesn't mean they couldn't. Or you have to make a great leap to assert that as of 1868, or even pre-1950, any of these states would have questioned whether or not they had the right to do so. Of course they had the right to do so.
And we've already addressed why they might chosen quickening as the line for their legal distinction. It had nothing to do with when they considered the child to be a person, but everything to do with the practical enforceability of the law that criminalized conduct that they couldn't really verify empirically at that time.
And so, one of the amici, the American Historical Association, an organization of American historians, which, man, is this embarrassing to come from a group of allegedly historians, suggests that the state criminal statutes shouldn't be considered because they were adopted for illegitimate reasons, like the fear that Catholic immigrants were having more babies than Protestants. And so abortion was leading white Protestant women to, quote, shirk their maternal duties. This is seriously what they have suggested. That this is like QAnon level nonsense. This is such
Everyone in the 18th and 19th century thought abortion was totally fine, but they banned it because Protestants weren't having enough kids. That's the argument.
This is equivalent to like the great replacement theory. Like, oh no, the Catholics are having too many children. We need to criminalize abortion because it's being used to replace Protestants with Catholics. Like,
yeah.
Are you serious? This is so ridiculous. Oh my goodness. Resort to this argument is a testament to the lack of any real historical support for the right that Roe and Casey recognized. I absolutely agreed.
Yep, 100%.
I seriously can't believe that's a historical organization that submitted that. That is embarrassing. Yeah. Breezing through page 29, there's ample evidence that the passage of these laws was instead spurred by a sincere belief that abortion kills a human being. And like that's the meat of it, that to be pro-abortion, you have to get around that problem. And that's why they come up with all of these loopholes and hoops to jump through of why was it illegal when it's clearly not a human being? Well, it's some other alternative reason, because clearly nobody from, pre-postmodernist relativism would have possibly concluded that these were human beings. Yeah.
Right.
On page 30, say Roe termed this is a right to privacy. So we're talking about the right to privacy here. And Casey described it as a freedom to make a, quote, intimate and personal choices. At the heart of liberty is the right to determine one's own concept of existence, of meaning, of the universe, and the mystery of human life. But
that is in there. Yeah.
Yeah, very important.
That's the passage I was talking about earlier.
Very important is the next statement here, that the court did not claim that this broadly framed right is absolute, and no such claim would be plausible, because while individuals are certainly free to think and to say what they wish about existence, meaning, the universe, and the mystery of human life, they are not always free to act in accordance with those thoughts. And here's a very concrete example of why that is the case. The Columbine kids were nihilist. They believed that life exists to be destroyed, and they chose to act on that. And there's a substantial portion of America that believes that very thing. And if you were to allow these people to act on that and say they have a right to it, you are condoning homicide, not only of unborn human beings, but of essentially anyone. And almost this would be an establishment clause issue, because if you're going to say you can act on this basis in a term that violates another person's right, then you are establishing a legal standard of religious belief. In this case, one of postmodern relativism and nihilism.
Right. Well, in the top of page 31, basically has even Politico highlighted this on in their release of it. It says, ordered liberty sets limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they termed potential life. But the people of the various states may evaluate those interests differently. In some states, voters may believe that the abortion right should be even more extensive than the right that Roe and Casey recognized. Voters in other states may wish to impose tight restrictions based on their belief that abortion destroys an unborn human being. Our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. So that's sort of the point here, is that it doesn't matter what you personally think about the mysteries of human life. Like, this is something that affects the right of another human, and so you are bound by the Constitution to respect that, or at least the Constitution does not bind you to the view that you should not respect that, if that makes sense.
Voters in other states may wish to impose tight restrictions based on their belief that abortion destroys an unborn human being. And that is why they're giving this power back to the states in the legislative process. If this is the question this turns on, whether or not it's a person or not, that's not for a court to decide. If this debate is nearly as intense as we all know it is, then that belongs in the public forum and in the legislature, not behind the closed door of a judge's chambers.
Right.
And the only other note I have on page 31 here is basically the crappy 14th Amendment jurisprudence. We've got the rundown right here: Griswold, Einstein, Carey. these rights to obtain contraception, and this is relevant to a Christian analysis of this, because when especially Catholics say that, like, contraception is a great evil, this is exactly how we know it's a great evil. You can judge trees by their fruits, and at the time that you start enabling contraception just for married couples, then you start enabling it for everyone, because how are you going to separate married and non-married couples? And then if contraception is okay, then what's wrong with abortion? Because clearly we believe at some point this isn't a human being. They don't have their own rights. It's not just a slippery slope. It's a clearly logical conclusion. You're going to end up at this result if you go down that path.
Right, which is why they end up comparing it to things like Loving versus Virginia instead, which is frankly a rather almost offensive comparison in my view.
I would find it so. Like the principle of me and my wife wanting to be able to be married in a free society is not comparable to people should have the right to murder unborn children. The fact that anybody thinks that is equatable is that our marriage is meant for, creating life and fostering life. It is not for destroying it.
Right. And the other difference is that Loving, I think, the right to marry is a common law right. Right. There's no common law precedent for the idea that. So just for context, Loving versus Virginia outlawed miscegenation, however you pronounce it, laws. So it basically said that states cannot make laws that prevent people from marrying people of a different race. And this one was not entirely based on the 14th Amendment, but even if it were, right, we could take it and see that the right to marry people of a different race is part of ordered liberty. It's something good, right? It's something that is at common law, it would have been recognized, right? There were no racial restrictions in common law for who you could marry. The idea that we would have a law banning any kind of marriage is a relatively modern one from the perspective of like post 1500 modernism. So the Loving case is not at all. It's not at all related to these other cases with the contraception and abortion, and the fact that they often will cite it is really quite disingenuous, in my opinion.
It's also not even just ordered liberty. Like Loving actually would be an equal protection thing, because the logic of this is, if I married a white woman pre-Loving, nobody would care. But because I try to marry a black woman, you're discriminating against me. That is per se discrimination. That
right.
The fact that race is being considered in how you deal with this, that makes it discrimination. So we don't even have to get to ordered liberty for this. It's just pure equal protection at that point.
Right. Right. You can find it in a different clause of the Constitution.
Yeah. Comparing the two is extremely disingenuous at best.
And race-based discrimination is exactly the kind of discrimination that the 14th Amendment was written to prevent. Right? That was entirely in the mind. Right, that was entirely in the mind of the people who wrote and ratified the 14th Amendment, was to prevent racial discrimination. So it's not at all comparable to finding some obscure right to privacy and drawing that out of the 14th Amendment.
Yeah, so on page 32 there's one kind of scary thing that Alito points out, that these criteria that they use to justify abortion at a high level of generality could license fundamental rights to illicit drug use, prostitution, and the like. That's exactly what leftists want. And so he's basically telling them the path they can go down to achieve these things.
Yeah.
Yeah, there's
another thing to point out is that he mentions Obergefell. He mentions Obergefell and Lawrence v. Texas. So Lawrence v. Texas is a Supreme Court case that said that you had a 14th Amendment common law right to engage in sodomy. Texas had a statute banning sodomy, and Lawrence v. Texas said that under the 14th Amendment, that conflicts with the right to privacy. Now, if you did the historical analysis that we just did on the question of abortion, what do you think the medieval English common law writers would have to say about sodomy? So these kinds of questions, Obergefell versus Hodges is the Supreme Court case that made same-sex marriage a fundamental constitutional right. Once again, if we went back, did this historical analysis, surveyed these writers, surveyed the history, do you think anyone prior to 1990 was arguing that there was a right to marry somebody of the same sex? So what we're seeing here in page 32 should raise doubts about the Supreme Court's willingness to enforce those cases, especially Hodges or Obergefell, because the Obergefell decision was decided on virtually the exact same spurious grounds as Roe and Casey, and now that wouldn't make gay marriage illegal, but it would leave it back up to the states because it's not a fundamental right found in the Constitution. Although,
which the states were already working on doing. Like, it was clear that at some point that was the conclusion, that the states and federal government were going to allow gay marriage anyway. And the court...
Right.
The court had more of a basis for discerning a, quote, trend in liberalization in Obergefell than they did in Roe by like a million miles.
Right. Well, and that's true, but there's also the fact that... To bolster the Obergefell case, even though I personally don't agree with the decision, there's an equal protection claim related to gay marriage that you can't really make about abortion, right? Because if you compare Obergefell with Loving, if I want to marry a woman, nobody cares. If I want to marry a man, somehow somebody does. So that raises the question of sex discrimination and thus an equal protection issue that we don't find in Roe or Casey. So it's a little bit more like you could support the Obergefell decision with a little bit more than just the 14th Amendment thin air right to privacy stuff. But Obergefell is definitely within that line of cases, the 14th Amendment line of cases, and so this opinion, if it goes through as it's been leaked, it would definitely raise some doubts about that decision as well. So,
yeah. I guarantee you at least one liberal is going to read that sentence about illicit drug use and prostitution and be like, yes, and that's why you should legalize all of them.
Oh, yeah, at least one liberal. Yeah. Well, I mean, we could talk a little bit, step away from the opinion for a second and talk a little bit about, from a Christian analysis, what is liberty, right? And, this is something we've kind of been talking around the whole time we've been hosting this event, but it's important to think about the distinction between liberty as the libertarian freedom to do whatever I might fancy, and liberty as the traditional freedom to pursue the good, right? And so from the Catholic perspective, I would argue that what true liberty is the ability to pursue the good without the government interfering, okay? So you wouldn't have a liberty to engage in drug use or prostitution because those things aren't good, right? They're bad. You don't have a liberty to do that. You don't have a liberty to kill unborn humans. You don't have a liberty to post pornography on the internet, right? You don't have these kinds of liberties because they're not pursuing the good, but you would have a right to raise your children in accordance with your values, or attend church, or synagogue, or whatever it is that you want to do that's pursuing some mechanism of the good. That's going to be what you have the liberty to do. And there's a conflict that, we can talk about it from the high level of the Supreme Court, but there's a cultural conflict even among conservatives about what the true nature of liberty is. And I think that that's something that's important to think about, especially if anybody listening is somebody who subscribes more to that libertarian. I don't know if Calix is still here, but if you subscribe to the more libertarian mindset, then it's worth considering where that path leads and whether that's something that's good for society or not. But it's also worth considering whether that is something that the founders would have intended when they talked about liberty, right? It goes back to what Alito was writing earlier. We use that word, but we mean 50 different things. So I don't know if you have any thoughts about that, Justinian.
Who was it that wrote that free will is the freedom to act within one's nature or in accordance with one's nature? I'm not sure if that was a singular person or if that was just a sentiment of medieval scholarship on free will, but I think that's
probably Aquinas.
Yeah, that sounds like Thomism.
Yeah,
I would say that's a good indication here of what liberty ought to mean. There's something to consider in liberty with dignity, that, as you mentioned before, there are certain things that no amount of consent should permit, because
right.
they're violations of human dignity. And I mean,
prostitution is a great example.
Yeah, I really wonder, can anybody... Well, there are people out there who will say, prostitution empowers women or whatever, and, that's awful, and, I'm sad for them because they're probably miserable people. But I wonder, is there anyone who would seriously say that meth addiction does not violate dignity? Even
right.
People who are extremely libertarian, who are pro-drugs, who, are completely relativistic in everything. Could even one of them seriously say that meth addiction does not, insult the dignity of the person it afflicts?
Right.
Someone might try to stick to that and be like, well, dignity is an ephemeral concept.
If they want it.
Yeah, well, within
right.
your definition of dignity, can you even say that? Like, if you have any definition of that word whatsoever, I can't imagine you actually concluding that allows for the dignity of the person afflicted.
Right.
And I think abortion is clearly within that camp of no one who undergoes it, no one who practices it, no one who is a victim of it can say that they are dignified in the process.
Right. This is why women who have abortions, many of them end up regretting it and feeling even traumatized by it later in life, because it's something that is, we all have this instinct, right? And we could get into the relativism discussion at a different time, but just as a brief aside, we can say that we all have different views on what human dignity is, but we all have a visceral, almost animalistic disgust when we see footage of an abortion, right? If you watch what some of these abortions look like, even on a sonogram, like, you can't watch that and tell me that that's consistent with human dignity. It's just not. Like you just nobody. You could make all kinds of philosophical, uh, mental gymnastics to get around it, but nobody watches that and doesn't feel disgusted by it. And I think that this view, we have a lot of people who lie, right? They lie to themselves and they lie to others. And I'm not just talking about others. I mean, we can sometimes do this as well as conservatives. If we're attached to this idea of libertarian liberty, where you can just make up your own rules and do what you want, we can find ourselves excusing things that are inexcusable. And I think that's something that's important to reflect on for ourselves as well when we see it in the culture with such an obvious horrible thing as this abortion situation. So
yeah. So on the note of relativism and degeneracy, on page 33, the defenders of Roe and Casey are noted to make the argument that without the availability of abortion, their freedom to choose the types of relationships they desire, is threatened. Why is that a concern? How does your wantingness to not have any responsibility, or to be able to, have sexual relations with people that you otherwise wouldn't be willing to have children with, how does that imply a constitutional right? How does that imply a right whatsoever? That is a horrible argument.
it's almost saying if I didn't have this ability, I wouldn't be able to degrade myself.
Yeah, exactly. It's which hopefully
I would
that's true,
have to
because I
respect
care.
my own dignity. Yeah, exactly. We care. I was thinking about this earlier, that we have this case. Let's assume that it actually becomes law and takes full force. Abortion will be banned in many states, right? It won't be banned in all of them, probably about half of them. But what we'll have is people will grow up in those states, right? Little boys and little girls who are just being born now today will be growing up in a world, in a state where abortion is not legal, right? And that can have effects, right? That can change the way that they view the opposite sex, certainly, but it can change the way that they view themselves, right? I think that this uncoupling of the sexual relationship from the responsibility of, or at least potential responsibility of, child rearing has caused people to degrade themselves. And I don't think we should underestimate the impact that laws and Supreme Court decisions like this can have, right? We saw this degeneracy form largely as a result of Roe. And now I think we have some hope to look forward to, that there will be people who otherwise would have been caught up in this that are now going to respect themselves and go on to have, happy, healthy families. So I think that's a really bright spot that we should be celebrating about this.
Yeah, I hope that's correct. We should probably speed along through Starry Decisis here real quick, because there's a whole section on this, and we don't need to get into too much detail, but we've explained Starry Decisis as a look to the previous court and an honoring of previous decisions so that courts remain consistent. But it's not a hard requirement, and it is, quote, at its weakest when we interpret the Constitution. Because if you don't, if you have no willingness to overturn prior court decisions, you are stuck with bad decisions for forever. Sans 13th Amendment, Dred Scott would still be the law. Sans Brown v. Board of Education, separate but equal would still be the law. And obviously these things are unacceptable to a society that, has dignity for people. There's one more example they use here of West Virginia Board of Education v. Barnett that was overruled just 3 years later, or excuse me, that overruled a case just 3 years prior about being compelled to do the Pledge of Allegiance. Well, the thing here, it's not the merits of the case that matter. It's that this was only 3 years apart, and absolutely nothing changed within those 3 years. Nothing of any legal substance changed within that time to merit an overturning of that case, and yet they did it. Clearly, Starry Decisis is not completely binding, and in the case of, cases that are just wrong, very wrong, it should be done. And this is the kind of case where, things are very wrong and it should be done.
Right.
So there's 5 factors Alito considers here of, should we use Starry Decisis or should we overrule this? The nature of the court's error, the quality of their reasoning, the workability of the rules they impose, the disruptive effect on other areas of law, and the absence of concrete reliance. All right, we have hammered the nature of the error. I don't think we need to get into that too much, but just to highlight the one sentence here of this is under the nature of the court's error, the first category. Roe was egregiously wrong and deeply damaging. It was on a collision course with the Constitution from the day it was decided, and Casey perpetuated those errors. And these errors are not some arcane corner of the law with little importance. The court has usurped the power of the legislature. This is a gross error. The quality of the reasoning, number 2, we've hammered that too. I think that they're finding an implicit right that is just not there, and that there's absolutely no support to say was implied there. It is to use a Christian term in law, it is modernism, pure modernism. Let's see. Here's
so the last one. Okay, go ahead.
Sorry, the point of Roe here, on the point of Roe here. After surveying history, the opinions spent many paragraphs conducting the sort of fact-finding that might be undertaken by a legislative committee. This include a lengthy account of the position of the American Medical Association, the position of American Public Health Association, as well as the vote by the American Bar Association's House of Delegates. I was astonished to read this. I don't remember seeing that in Roe because it's been forever since I've read that case, but reading this now, my jaw dropped. That is not something a court should ever be doing. That is so outside of their authority, and yeah, it's appalling.
It is. I wanted to focus on the last factor, which is the nature of the reliance on the opinion. Because this is the one that all of us here, all of us Christians who have been in the fight for life, this is the one that we actually affect. Okay? So one of the principles of Starry Decisis is that we want to have the law be settled so that people know what the law is and they can move on with their lives. Right? And Justice Alito's fifth factor here is basically saying that there is no reliance on this decision because it's remained a controversial area of law for 50 years, right? And that's because of us, right? That's because of pro-life people who have not let this die. They've not let this issue go down. They're passing laws in their states 50 years after Roe was decided that brush right up to challenge it. And so this is something that's important because this factor it should not be underestimated, right? This case would never have been overturned, right? These cases would never have been overturned if there was lockstep reliance on the precedent throughout the whole of American society. So I think we should all be taking this section of the opinion as something of a pat on the back from Justice Alito and the other justices, saying, thanks for doing your part. We're the ones that kept this alive, ongoing controversial issue that prevented it from becoming the kind of stare decisis that is just sort of baked into the cake in society. So, yeah, that's something to think about.
Yeah, on workability, the fact that Casey couldn't even uphold Roe's framework, I think, is the biggest condemnation of workability of Roe. And Casey's framework is no less completely arbitrary. And Alito doesn't outright say it, but we touched on this previously, and I think this raises an equal protection question of its own. If viability is the standard, then why does an unborn baby of 25 weeks in rural West Virginia have less of a right under the Constitution than an unborn baby of 25 weeks in Baltimore?
Right. Because the viability is going to be different.
Yeah, it is
right.
Inherently class-based in a pretty significant fashion. So yeah, its workability is there isn't any. That's another reason this has been a constant issue.
Right.
And the last would be the effects on other areas of law. This is Justice O'Connor dissenting from another case here that we haven't talked about. No legal rule or doctrine is safe from ad hoc nullification by the court when an occasion for its application arises in a case involving state regulation of abortion. She's basically lamenting that any statute that touches abortion whatsoever is subject to just random repeal by any court in any jurisdiction, because the standard on how you interpret these abortion cases is so all over the place. The court's abortion cases have diluted the strict standard for facial constitutional challenges. They have ignored the court's third-party standing doctrines. They have disregarded standard res judicata principles. They have flouted the ordinary rules of severability of unconstitutional provisions, as well as the rule that statutes should be read where possible to avoid unconstitutionality, and they have distorted First Amendment doctrines. The effects on other areas of law, to the extent that there are any, and there are quite a few, have been just completely to steamroll it. Abortion takes precedent over everything, and that's true, because look at how much the liberal left and progressives are motivated by this decision that isn't even finalized. Every case. That
look at how it affects.
Yeah, go ahead.
Look at how it affects Supreme Court appointments.
Yeah.
Right. I mean, this hangs over everything.
Yeah, anything that touches the law, there are people out there always questioning, how does this affect my abortion rights?
Right. So that is pretty much the entire case. Right. Once we went through those stare decisis principles in pretty quick succession, but that's because it's mostly the kind of legalese that people are not going to be as interested in.
Yeah, there are a couple minor points at the end here that I like to point out just because they're so well done. One of the things that Alito points out when people say, we need the Supreme Court to protect abortion. Women are not without electoral or political power in this country. And in fact, their political power outmatches men most of the time, because they vote and register in higher numbers, and they're a greater percentage of the population. The judicial branch does not derive its legitimacy from public opinion. They're not elected. They're there to interpret law, and they need to do so independently. If something is to be determined by the legislature, it should be determined by the legislature. And so, with that conclusion, finally holding that there is no right to abortion and Roe and Casey must be overruled, he just lays out very briefly. So, what is the standard for analyzing abortion laws? Rational basis. That's it, and that is an extremely lax standard. That's basically the most lax, I think. I don't think
it is.
Get any more presumptive in the state's favor.
Almost nothing will ever get overturned on rational basis grounds. I don't know if I've ever read a case where something got overturned on rational basis review, actually. Now that I'm trying to think of one. It never happens. You'd have to have a legislature pass a law that makes no sense. There's no tailoring. It's none of that. It's not scrutiny. It's not any kind of scrutiny. It's just rational basis. That's the biggest win in the whole case. For those of us who are pro-life.
Yeah, that gets us through the whole opinion. We did seem to skip like 15 pages there, but that's all stare decisis of an explanation of arguments we had already covered. So don't worry, you didn't miss anything important in there.
Yep. So a couple things that I want to mention in terms of practical effects. First of all, this case seems to suggest a couple lines of argument that could be used to later create a fundamental right to life, right? Because if you think about incorporating 14th Amendment rights that were recognized at common law, I think you can make a pretty strong argument that based on all of these anti-abortion laws that existed at common law, that there was actually a right to life for unborn babies at common law that would have been incorporated into the 14th Amendment when it was adopted. So I think this is setting the stage for that. They're obviously not willing to go there now, but I think it's something that we could see in the future if we keep fighting this fight. We could see that actually become constitutional law that you have a right to life even before you're born. A couple other things is that this is now, it's the ball's in our court. So every state is going to have the opportunity to pass laws related to abortion. Some already have. Some have already even put in their state constitutions that if Roe's ever overturned, abortion's banned. So it depends on where you live, but it's going to be our job to make sure that we advocate for pro-life laws at the state level, right? That's not going to happen automatically. And while some governors are already talking about banning it entirely, we're going to get some governors who want to waffle and make a bunch of exceptions and all that kind of thing. So this is not an evil that is gone. It's just we now have the political space to actually do something about it. So it's not over yet as far as that's concerned.
Yeah, and
then
to be clear, this opinion isn't even final right now. This opinion was leaked before it is final. Now, that said, this decision is not changing. The at least 5, possibly 6 people who voted for this decision have been waiting for this their whole careers. They're all baptized Catholics, and the one that is no longer Catholic is still a Christian, just a Protestant. So
yeah,
like their values are not going to bend from this getting leaked. On top of that, this opinion, if they were to rewrite this, this is weeks, if not months of work right here. So that's not going to change. You might see some minor revisions between this draft and the one that is actually released, but the substance is gonna be this.
Yeah. The last thing I want to say is just to prepare you for the kinds of arguments you're going to hear. You're going to hear the typical "my body, my choice" thing, and that's unsophisticated. We don't even really need to address that. But you're going to hear the Starry Decisis, right? You're going to hear the complaints about how the conservatives just upended the court and they don't care about Starry Decisis. This is a disingenuous argument because liberals also do not care about stare decisis. They're happy to overturn precedent when it suits their political purposes, and the pearl clutching about stare decisis is extremely hypocritical, to say the least. Also, some of the most celebrated cases, if not the most celebrated cases in our Supreme Court's history, have been cases where stare decisis was ignored. Brown versus Board of Education is a perfect example of that, because Brown undid Plessy, which basically said, nope, no more separate but equal. We're not having that anymore. That's gone. So that's one of the most celebrated cases in Supreme Court history, and that's an example of stare decisis being cast to the side. So don't let people clock you over the head with the stare decisis claim. It's a Latin phrase, so people will feel smart, making that argument. Just be prepared for that. It's not actually it's not really a serious contention.
Yeah, people always talk about precedent when it comes to the court, and precedent matters, but it has never been controlling. That's not how common law works.
Right.
Let's talk about precedent and authority real quick. Okay, so when you have precedent, there are times that it is controlling, but it is only controlling, one, if a higher court over your jurisdiction has said so, or you, as the exact same court, have said so. If you are, and even that one we've seen the Supreme Court will wiggle on, but there's an expectation that courts will abide by their own opinions, at least from their own institution, unless they have significant reason to differ, which we have gone through, 30 pages of stare decisis analysis of why that is inappropriate here. And good luck actually refuting any of this, because it's solid. So we've addressed the same court, and then a higher court within their same jurisdiction. There's no such thing in the Supreme Court. They're right. The top. So there is no precedent that's binding to them.
Right, but their precedent will be binding on all the lower courts.
Yeah, the rest of the country has to.
This isn't the kind of thing some random judge in Hawaii can decide he doesn't like and ignore. He has to follow it. So, yeah, I think we've covered everything. I hope that is helpful for people. Do you have anything you'd like to add, Justinian, before we close?
Just to, humble brag that IHS attended the last March for Life before this was determined, so yeah, boys, we did it.
Yeah. And like I said, and like Justice Alito basically says to us in this opinion, we've kept this, I'm speaking like I've been alive for the whole time, but Christians have kept this issue alive for 50 years, and that makes a difference. So everything you do, things like attending the March for Life, supporting the March for Life, supporting pro-life political candidates, just talking to other people about abortion and why you oppose it, that's all good. That's all helpful, and that makes a difference even at the top level of our government. So keep it up.
Yeah, I think that's a good conclusion right there.
Yep. All right, cool. And then we can stop the recording.
Thanks everyone for joining us and watching.